Dear friends, we are almost punctual and are about to begin our roundtable almost on time. And I would like to draw your attention to the fact that one of my very esteemed colleagues said that this is the only roundtable discussion at the forum, and I'm saying that out loud so that other roundtable discussions can hear it, that it deals with business protection. There are very many international themes, philosophical or legal, so we spoke about the legal department and the digital age. However, this roundtable discussion is intended to focus on how we can best protect business prior to the bankruptcy procedure or during the bankruptcy procedure, basically speaking, at all stages of pre-bankruptcy, bankruptcy procedure and the final stages of it. We are happy to have the best experts in the field of bankruptcy, not only bankruptcy, but in the field of responsibility, from the managerial perspective, from the shareholder perspective, representatives of the best legal firms, and we hope that we're going to just prepare the proceedings upon the discussion, and I would like to encourage your active participation in the discussion. Pavel, please wake up. We are going to vote. We're going to have we're going to consider very interesting issues, and just we will write about it in our publication, you in your publication, Kommersant. So I hope that you will advocate the subject matter at our table, because this is an important team, and you have to stop by anyway. So I'm not kind of trying to lure you to participate. This is an interesting topic. We have about 2 hours, which brings us to the time frame of 10 minutes per each speaker. And the remaining time will be reserved for question and answers, comments, opinion exchanges, and we'll ask questions of you. Don't be afraid. These are going to be interesting questions that will help us understand what concerns the public has and can voice and discuss. So we are beginning. We're going to have a voting. And please take such devices from a box, because we're going to offer you interesting questions to answer and vote over towards the end, probably, of our meeting. So now I would like to turn the floor over to the esteemed Елена Diomina, the partner and del Credere company. We try to cover all the possible aspects and dimension of this topic, though it was a losing game to play because they are so wide-ranging. However, Elena will tell about the bankruptcy insolvency law from the debtor perspective. So this session is a counterbalance about the banking session that looked at the novellas in the insolvency and bankruptcy legislation. So, Elena, the floor is yours. Please speak to the mic and loud enough. Dear colleagues, good afternoon. To pick up on the introduction that Alexandra just made, the topic of our roundtable discussion is focusing on the business protection and the debtor's business in the bankruptcy-related process. This is quite a rare topic. So the judicial practice and legislative practice, the major victim is the creditor, and we need to protect its interests in due way. However, the interests and concerns of the debtor were traditionally neglected. So the first insolvency law was established in 1991. They were all pro-creditor. So sixth law in 1997. So just then they forced to turn the legislation towards the debtor, interests and concerns, and apart from providing protection to the creditor, we need to strike a balance between the interests of creditor and debtor. So just there are provisions in 2002 law to provide for the interests of the debtor. I'm not going to focus on them in depth because they're very well known to all of you, but basing upon the most recent changes introduced by law 847, so the debtor's happiness period was not a long-lasting. So what I would like to focus on in my presentation is the following. While I was preparing, I looked looked at the draft law and just both the wording and just the annotation to it. So the changes that are about to be introduced is just the tip of the iceberg in terms of the plethora of changes that were to be introduced to restrict the debtor's rights. And in the previous session, it was also mentioned that the rights and responsibilities of the creditors have been extended, so they can appeal without any court decision. However, in the wording of this draft law, it was said quite different things, not only extending the rights of the credit organizations, it was seeking to extend the responsibilities of all the bankruptcy creditors and debtors and other stakeholders. And as in the annotation, it was stated that why this novelty was to be introduced, and as the law drafters were governed by the disbalance and infringement on the creditor right situation, because the creditors, in order to apply to the court, first have to have the order of collection in place, and the bad faith debtor shouldn't have done that. So there was a preference, a bias towards the creditor, and so the law drafters decided to strike a better balance between the interests of the debtor and the creditor. I don't know why the Duma only adopted these changes in a pro-creditor way. However, if they had this position, so in the future, just we might face this in real practice. As to the restriction of the debtor who applies to the court, he is now denied the right to identify as the bankruptcy manager themselves, and just the law developers decided that unfair debtors abuse of this right, and just they would tend to engage a loyal bankruptcy manager that will provide for a better control of their business to the detriment of the creditors. This draft law also continued a number of other provisions that have not been adopted yet. So it was draft law 482, and the changes, they are not adopted yet, they are rejected. However, this opinion is the law drafter's opinion, and it is well reflected in the annotation to the draft law. So they want to extend the creditor right in the bankruptcy procedure and to have a tougher regulation for the debtor rights and obligations. And one of the examples of that is that this was also proposed, a provision to the current payments in the bankruptcy procedure is very broadly defined, and the debtor can spend the monies to his own at his own discretion. And it was proposed to restrict the notion of the current payment, so that it is restricted to the current activities of the debtor. Then there was another proposal to identify the right of the bankruptcy asset to be just sold in the procedure. Why I'm saying that? Because the position of the authors was targeted at restrictions. So far, these amendments have not been approved and adopted, but this is a trend, so we might expect these restrictions to be approved of at a later stage. But in terms of the just the positive opinion shared by the law drafters, so there were amendments proposed to Section 3 to the insolvency bankruptcy law. There was a proposal to change it, to change the whole approach to the major parameters of the bankruptcy, tightening the obligations of the debtor versus extending the rights of the creditor. Attempt was made to limit the number of claims that could be underlying the bankruptcy procedure. Our only current criteria is a non-paid sum for a certain period of time, but in the wording that was proposed but then rejected, quite a different approach was taken. There was a number of criteria to the unmet claims, and that could have triggered quite a different bankruptcy procedure. I don't know why the Duma rejected these proposals. They just increased the sum, the threshold for bankruptcy procedure from 100,000 rubles to 300,000 rubles. And it is also very important to mention that there are also changes in Article 14 and 13 of the Administrative Code, additional responsibility. Because who failed to notify in due time the creditor about the signs and signals of bankruptcy, and there are some sanctions about the failure imposed on the grounds of the failure to notify. So these are the major trends, not very positive for the debtor, that we might expect to face in the future, and also very shortly, which is a rare topic for the discussion. So I just bankruptcy law through seen with the debtor's eyes, and I just wanted to simulate some situations. So in which the debtor might find himself, and how in the existing legal space he can respond to the situation. Situation 1, the debtor has certain financial problems. There has some court claims, and he understands that he cannot cope with these financial problems currently, cannot meet all the obligations. However, he has a certain resources, and he wants to save and retain his business. What they can do in such situations? We very often recommend the debtors to initiate the surveillance supervision procedure, because this is a way out. Because the debtor can pull up all his monies and financial means in order to repay the debt. So this is a breakdown for the debtor. So the debtors do not stifle them, so that they have this moratorium period, and there is a bankruptcy manager, liquidator, not probably even a very friendly one. However, in the monitoring procedure, so the debtor cannot appoint his own bankruptcy manager. Yes, the court can do that for him. So let's hope that the court will always be objective, and the bankruptcy manager will be an objective and a good candidate, because basically he has very limited rights of interfering within the debtor's activity, and the company management is retained. So the manager keeps the register so that the debtor can understand who has which claims or issues to raise with him. Why are we doing that? At the end of the bankruptcy procedure, we aim to reach the amicable agreement with the creditors. Why I'm talking about this figure of the bankruptcy manager and that he is not so important, because in order to reach the amicable agreement through the monitoring procedure, one does not need the opinion of the manager. There is debtor's resource and the goodwill of the creditor. So when the debtor has some current problems, however he wants and makes an effort to find a way out. So this procedure leading to the amicable agreement is a favorable and welcome one. Second situation, when the debtor's situation is much worse than that. When the creditor situation is even worse, sometimes in practice some norms are applied. If a business, if somebody wants to transfer the business to another persona, so if there is a will of a debtor to do that, in practice we can resort to such norms. Before the bankruptcy procedure starts and before the petition finding, there is a decision taken on the voluntary liquidation, which gives rise to the foundation of a simplified procedure. However, the practice here is wide-ranging. I'm speaking so fast because I cannot fit within the time frame allocated for the presentation. It's an interesting topic because the application practice is really wide-ranging and quite conflicting at times. Some people think that some rely upon the decision about the liquidation taken by the stakeholder. Some think that there should be some liquidation activities taken and the liquidation reserve in place. And in different disputes and situations, we can resort to one or another position. So, and the third situation is the most lamentable for the debtor. I'm just winding up very fast, and this is the worst possible situation for the debtor. There is no way out to exit this procedure on his own, no interests on behalf of other stakeholders. It is very difficult to recommend anything on the exit possibilities. So the debtor's effort should be concentrated on how he can avoid subsidiary responsibility, but it's a different story. So if time permits, towards the end, we can also so give me just 3 additional minutes to wrap up, if possible. Yes, so this is an issue which is quite important for members of our association. So the subsidiary responsibility is a topical issue for many of us. We spoke about the criminal liability. Just another 3 minutes. of your time. I just wanted to share it. You are all very professional and qualified representatives of legal profession here. However, I would like to share some thoughts which were prompted by my practice. We had many cases related to bank bankruptcies recently, so we dealt with ISV, just very active in law enforcement, and I noticed that I never saw a practice of them filing just claims for subsidiary responsibility, to substitute them for the damage recovery petitions. And I'll explain why I think they do so. Subsidiary liability is introducing a limitation within the sum that was missing to repay the debt, and when all the repayment is done, if you see that something is missing and within the boundary of the missing sum, you can just do that. But in the second case, they don't connect it either with a certain stage or a certain sum cap, and they just use the 67th plenum practice. So this is quite a popular practice, which you have to remember, and understand how you can balance it. Another thing in terms of the bankruptcies is a position which I personally do not share, especially speaking about the debtor's perspective on the bankruptcy this session. Damage recovery from the management that did some that because of their wrongdoing the damage raised. So this just company files this claim to the board of the bank, and just then the letters say that the credit agreement is the foundation for such action if they are concluded with the insolvent debtors, right? That was seen right from the outset, and they never reacted on this. However, the people who were in the board were the members of the credit committee at the same time. Credit committee is not the managerial body according to the bylaws. It's advisory entity, and there is no liability provided for the members of this committee. Still, the practice is the following. If they never voiced their will as the members of the board, but they spoke in their capacity of the credit commission, they can be found liable, and damages can be claimed also within the 67th plenum procedure. I disagree with this practice. I think we need to stick to the law provisions for the management members, but we need to understand that this is a practice and we need to counter it. So I hope that other panelists will share their views of the responsibility positions, and I basically ask you to be as practically oriented as possible, not just to retell the wording of the laws, but offer some practical solutions. It's not a secret that the bankruptcy cases in Russia is a hostile takeover in essence. And it happens because so it's just not the debtor that is the victim, but this is the owner of the debtor, because the control over the asset is lost momentarily. The question, do you think that the legislators can probably think about protecting the rights of the owners in this procedure at all the stages? Thank you. It's a very good question. It has to be ensured, of course, and in the law of 2002 versus the law of 1998, this step has been made because in the previous laws there were these rights have to be further extended because the bankruptcy law has to be targeted not only at protecting the rights of the debtor only, but all stakeholders in the process.
Let me just comment, if I may. Svetlana Karelina, PhD in law, Moscow University, the Faculty of Law. Let me just provide you a comment on the questions from Elena. Why wasn't the article accepted after the third revision? So it wouldn't be a secret for me to say that the new versions of the articles were prepared by the banking community, and these articles have been discussed across various platforms, which I mentioned at the previous discussion, and the Article 3 wasn't an exception here. So I think a lot of effort was spent on trying to prove and trying to convince the communities. And when it comes to the legal technique, the first version of this article was basically illiterate. I'm sorry for the harsh words, but it was legally illiterate. So I'm not going to go deeper into the discussion about the ratio of the criteria, because one criterion was defined through another one, again in a completely illiterate manner. But thankfully, we did manage to facilitate the passing of the article in the version that was acceptable for the community. Again, like I said, it's required a lot of effort. The substitution of assets of the debtor and replacement of an asset and so on and so forth. If you may I ask you a question, Svetlana? Svetlana, yeah, I understand what you're trying to say, and I do agree with you. But again, the version of Article 3 that wasn't passed, yeah, it's overly complicated, would be very difficult to implement. But don't you think that since there is a trend in the law to basically expand the rights of creditors and to limit the rights of debtors, don't you think that the Article 3 should be changed, maybe in a more literate manner? Yes, I do think so. Of course, I do not want to appear either pro-creditor or pro-debtor here, but I have to say that the way that it is now, the law is favoring creditors. It is a pro-creditor war because the main competitor creditor under the law is a bank. And of course, here I'm siding with the debtors. I support this position, and I would like to emphasize one more time that we did manage to protect this law during numerous meetings of the Association of Russian Banks. So again, what we managed to protect stayed in the law, but of course, like you said, the law is a pro-creditor law, but I cannot really say what will be the defining trend in the next 2 or 3 years. The agency for the insurance, does it work? This is the agency for the insurance of bank deposits. So I would like to comment your speech on the subsidiary responsibility. I know that we have more than 120 claims, probably 140 claims for the legal and civil responsibility during a bankruptcy procedure, and only 48 of these are the claims on losses, and the rest are the basically claims of subsidiary responsibility. So I think your reprimand is not really true. Well, that wasn't a reprimand, but I would like to say that sometimes we experience attacks on the essence of the claims on subsidiary responsibility and the claims on losses, because again, if we start discussing this subject, then it will be just the two of us talking. I do not really think that anybody files more claims on subsidiary responsibility than us. So if you're interested in this sort of claims, especially claims to credit institutions in which, for instance, I work, so let's just discuss it afterwards. Yes, it's a very sound proposal. And again, when we are moving to the discussion on the legislation, I see Anna Maslenikova here. She is the leader of our banking association, and maybe banks should also participate in the discussion because we have a lot of members. Some of our members are banks, some of our members debtor organizations. Yeah, good morning, good afternoon, dear colleagues. Let's maybe continue this session. Let's not dwell on this heated topic because, you know, we have a lot of many interesting things planned for this session, and then maybe when we are finalizing this session, maybe people will actually change their opinion on the topic. Thank you very much. So let's upload our speaker. Because we discussed a lot of practical things, no wonder that it generated such feedback from the audience. But this is Valery Zinchenko. He is a senior partner from the law firm Pen and Paper. He will talk to us about criminal responsibility and about how to protect. No. If you allow me, I would reformulate what you said. Yeah, sure. But let me just say a couple of words. When it comes to criminal responsibility of the management, criminal responsibility of the founders or the stakeholders, these issues are very important. And during a previous session, we talked to the members of the Association of Corporate Lawyers, and they said that they perceive their main objective as a protection of top management from criminal and civil responsibility, especially criminal responsibility. When such cases appear, then it makes the existence of any company very complicated. Thank you very much, Alexandra. Good afternoon, dear colleagues. I'm very grateful that you actually found the time to attend this session, which is scheduled for the last day of the legal forum. I would like to thank Alexandra for being very brave and very courageous preparing this session. I think that's the first time when I encounter such a responsible approach from a moderator, but it is a very topical issue, protection of business in bankruptcy. But my idea is that when we start discussing protection of business during bankruptcy, what do we do so we do not threaten the freedom of our top managers, of our stakeholders, and maybe our own personal freedom. Let me just start by giving you some statistical information. Basically, the scale of bankruptcy as of January 2015 exceeds the number of the same claims in 2014 by 50%. In 2014, 20,000 petitions for bankruptcy were viewed. There are also verdicts that were issued on these cases, and about 146 cases ended up in the court. But again, the statistics that I'm giving you cannot really be explained by the very nature of such criminal violations. So what is the cause of such low statistical figures? Well, first of all, I've been saying at different conferences that the level of professional qualifications of our law enforcement agents is improving. But again, the bankruptcy topic is so complicated that even though they are well versed in corporate law, the law enforcement authorities are not too well versed in bankruptcy law. But I don't think we can count on it being true forever. The second reason is for the statistics is basically the emptiness of these articles that exist under the law. So, the law is being changed quickly, so the criminal code lags behind all of the amendments. All of these amendments that are being introduced into the law. So why are we talking about criminal risks or the risks of criminal prosecution if the statistics is so low? But again, I wouldn't be too happy about it. I wouldn't just breathe out and relax. We know that there are a lot of simpler economic articles that our colleagues can use to initiate bankruptcy investigation procedures, such as Article 159, 165, 201. So we shouldn't really relax when we're talking about the special subjects that are reviewed by these bankruptcy articles. We know that it is either a participant of the company, it's manager, or the stakeholder of the company. But it's not a secret that a lot of the lawyers use borderline schemes, because they do think that it will be the top manager who will be brought under criminal investigation, not the lawyer. But we do have a part of the article of the criminal code which says that if somebody is suspected of criminal activity and they do not conform to the features of special subjectivity, then they can be trialed as an accessory. So we cannot really hide behind this definition of special subjectivity. It doesn't really help a lot of people. Also, a lot of lawyers believe that sometimes the investigation encounters difficulties trying to establish when the criminal violation has ended. Sometimes the investigators initiate a lawsuit, but then the prosecutor doesn't approve it because the prosecutor says that the large-scale damage hasn't been proven, because again the procedure hasn't been initiated, because basically I do say that in practice it is we are moving away, and as Kelly Reznik said yesterday, I wouldn't agree with him that our criminal justice system looks like the Inquisition, but Article 145, Part 1, salary indebtedness. You know that a lot of the companies that are going through debts are late with the payment of salaries, and it is not just a risk. Basically, it gives us grounds to initiate criminal proceedings. And again, a lot of prosecutors, a lot of investigators use it as an excuse. They conduct a search, and then they can even requalify this article to be used in bankruptcy cases. Let me just give you a couple of examples that I've seen in my practice. First of all, what we need to do, we need to save the assets. I think a lot of you have probably heard about a so-called mirror enterprise, when we can use internal lawyers or consultants to transfer the assets to a mirror company, and following some time, the company starts operating under a new name while the previous company is liquidated. This is a very typical case when a large textile holding, for instance, made a decision to go through a liquidation procedure. Large creditors of the holding initiated a bankruptcy procedure, and it turned out that several months prior the initiation of the procedure, they sold their regional network, which includes 50 legal entities and everything that was in stock. And it might seem that there were no legal risks, but when a person was hired to work in the new structure, they listed an old address and the domain name of the old company. So basically during the investigation, it was identified that the new company was established by the ex-employees of the previous company. And even the lawyers were held responsible under Article 159. So maybe to conclude, I have to say that my aim is not to be a scarecrow in the area of civil law. No, Valerie, you have to scare us a bit because we have to learn about the risks. Well, the risks are clear. Do not pay too much attention to the special articles dealing with bankruptcy. I do believe that sometimes enterprises contact us quite late and they tell us, well, we do have a scheme in place, we're trying to save ourselves, and then they bring us the transactions once they've been made, when they tell us that the assets have been transferred to offshore zones, and then they usually reprimand us for not offering them the right recipe. So I have to say that once we gather together and try to make a decision how we can save the assets, I still think that the top manager should be at the head of the table and the criminal lawyer should be at his right-hand side. Thank you very much. I think it is great that you actually did give us a couple of recipes and a couple of recommendations. We know that delays in salary payments seems like not such a terrible offense, but it's not the case. Yeah, I would also add that a lot of people believe that, again, failure to pay the salary does not result in a criminal sentence, but actually it can. There is an Article 201. We had a case several years ago when the CEO was jailed for 6 months. And what is Article 201? Well, the abuse of authority, abuse of power. Well, in any case, I think it is very useful information. We held a roundtable discussion at the meeting of the corporate bar. So we were talking about the responsibility of the top management and of corporate lawyers. Sometimes it is really deplorable when the corporate lawyers do not really think about the well-being of their management, but they have to, because it basically comes down to their own well-being. So this, again, if you'd allow me, I would like to say that it is not just the responsibility of corporate lawyers, but sometimes I'm really surprised to learn about the position of our consultants. For instance, our client got an email from a well-known consulting company where in their commercial proposal they are describing things such as, the increase of creditor indebtedness or controlled bankruptcy. So basically they're offering us these things as services. So basically it's not just the corporate lawyers or the internal company lawyers that are to blame. So you're saying it's a different topic about how we should develop legal practices, what sort of services should be offered. I think it is also an interesting topic, and maybe we can really share this information. So I think it is really important for us to remember what you said. It is both important for in-house lawyers and for consultants. Maybe somebody has questions. Well, I'm interested to learn about the statistics. Can you raise your hand if you participated in a bankruptcy procedure and you encountered criminal risks? Yeah, just raise them. Maybe it's higher. See, almost half. Slightly less than half, I would say. And I also have a question to our Japanese colleague. Maybe he can, during his speech, touch upon the situation in Japan. Which situation in Japan? Well, about the criminal persecution of bankruptcy. Maybe he has some statistical information about it. Would you be able to do it? Would you be able to say something about it? My name is Klim Rusakonska. I'm a manager and company of the Paradigm legal company. I would like to ask you, in your practice, which are the most used article about the bankruptcy law? 159. This is not even a bankruptcy law, but basically it just covers so many things. You can do whatever. And what is it about? It's about fraud. Yeah, I agree with you. It is true. Valery, can I ask you, have you had a case of bankruptcy which had no real fraud features? Well, if you're honest with me, where everything was done in an honest way. Have you ever seen such bankruptcies where everything was fair and done under the law? Well, since my company specializes in management of criminal risks, such companies do not contact us, unfortunately. And maybe somebody in the audience had, I don't know, a bankruptcy procedure where everything was really fair. 3 people. No, 4 people. I have to say that, yeah, I've also encountered this in my practice and not just once. I don't want... And, oh, yeah, even more hands there. I would like to comment on the issue if I may. I'm really sorry for interrupting. My name is Valery Shkret. I am a member of the Moscow bar. Well, according to my information, I have to tell you the majority of bankruptcy cases are usually reviewed under the law and within the framework of the law. And it happens because there are a lot of enterprises which have long history, a long experience, good reputation, and they end up in bankruptcy, so they have to go basically through bankruptcy administration and liquidation, but none of them actually contact law enforcement authorities under Article 159 or Article 195 or under other article of the Criminal Code. So I have to say that we do have a normal bankruptcy procedure. So we see, well, there are a lot of positive things, and right now let's upload our previous speaker. So I have to say that I would like to continue the discussion with each of our speakers. So I would like to give the floor to Vasily Raulin. He is the head of the bankruptcy department of the legal company used. Well,
so I would like to participate in the discussion about the intention of the creditor to bring the debtor to bankruptcy. I dealt with bankruptcy cases multiple times, and I didn't have any criminal components or fraud, like the colleague said. Everything was fair, so that just the company just happened to fall into the debt abyss, and I just don't want the audience, especially those of us who do not deal with bankruptcy procedures in their daily routine, to have an impression that the bankruptcy field is a miraculous area where everything is based on dissipating assets or on just some collusions and so on. In terms of the percentage, the bankruptcy cases are jurisdiction disputes mostly, and this is my opinion, and this is what I see in practice. Now moving towards the theme of my own presentation, which I thought to be practical, how you can protect yourself from the intentions of the hostile creditor who seeks to bring your business to a bankruptcy. Now I'd like to begin by saying that it is easier to prevent the bankruptcy than stop it once it's triggered off. If you trigger off this procedure, it is very difficult to cope with it. So the major companies that are interested in saving and rescuing their business that might experience some temporary financial problems need to develop detailed anti-bankruptcy strategies that will be targeted at preventing initiation of the bankruptcy procedure by hostile creditors, and these procedures can be proactively developed before the thunder hits or before the company finds itself on the verge of bankruptcy. My company, as well as many other, offer integrated services to our clients in developing these preemptive or preventive anti-bankruptcy strategies that help to avoid these risks in the future. This is quite a service that is becoming increasingly in demand on the market, and depending on the specific setting, specific business, and the composition of creditors, we offer the following strategies to our clients. Especially if a company is financially successful currently, it will tend to think that this fate will never befall them, and they will be 100% avoiding these potential risks. But one of the old books said, what used to be will be, and there is nothing new under the sun. And many people burned their hands when they thought that their business will stay untouched, and they will be successfully avoiding any attempts of hostile creditors or takeovers. However, practice proves the opposite. This can befall any of businesses. And here it is very important to ensure good coordination and exchange between legal experts and economists. So economists and legal profession representatives do not always see eye to eye, and they might have their disputes because legal experts that do not understand why the credits are called loans, or economists think that if we listen to what the lawyers say, we'll have no economic growth or profit unless we go for a little reasonable risk. But then a legal person comes and saying you are going on the going for unjustified risk. Shall we slow down and be happy with what we have? However, this dialogue should be there, and the representatives of these two professions, economists and lawyers, can do a lot together to prevent a company from a bankruptcy. These strategies can be more or less universal, applying to general bankruptcy cases, as well as very specific, especially tied up with the specialist area in which the business is carrying out its activity. So first and foremost, it's a qualitative analysis of economic indicators, current economic indicators of a business, and then having a detailed projection of the further development in the future. From legal perspective, it's analysis of the agreements with the counter-agents of the company to identify the status of these companies on the market. We way too often forget that in our digital age and information age, those who own information own the world. So if we spend just half an hour our time to look at what data can be found about this or that company from open sources, we'll be able to learn a lot about this company. We will know what they will like to hide under the corporate veil. The internet, which is a major source of information, as well as many others, provide a lot of data. However, people neglect this opportunity, and very many negative situations could have not befallen the companies had they took pains to collect this information, because some of their counter-agents are already on the verge of bankruptcy, meaning that the transactions are going to collapse, they're going to be a loss of property, slowed down growth, and everything that might further entail the bankruptcy. And the company, which never did its home task to study the position of the creditor, which might be precarious, might find itself in a dangerous situation. So how we can build up the dialogue with the creditors that are bank organizations as well, because banks have received specific advantages under the new wording of the bankruptcy law. So they can initiate the simplified bankruptcy procedure. which in turn makes debtors, or should make debtors at least, to build up a dialogue with the creditors and the banks in order to restructure their debt. And that is, as it rightly said, in terms of the bankruptcy of the physical persons. So it's not just restructuring most of the cases, it's just the rescheduling of debt repayment. Can you talk a little bit louder, because and speak closer to the microphone? Yes, of course. We remember that in order to retain a business, the debtor needs to maintain an ongoing dialogue with its creditors, because I think that all of us who dealt with bankruptcy in practice knows that once this mechanism is triggered off, it is very difficult to stop it or suspend it. So when the bankruptcy procedure begins, both creditors and debtors are in somewhat turbulent state, because even sometimes there are comfortable relationship between debtors and creditors when one can find an agreement. And during the official bankruptcy, intervention of the state is ensured. It's arbitration trustee, it's the court, the entities that will affect the bankruptcy proceedings, and this might be not very welcome, might not be welcome both by the creditor and the debtor. And here this turbulence will persist for a long time. Sometimes it is difficult to undertake any actions. So I would like hence to support that prior to bankruptcy proceeding, at a pre-bankruptcy stage, the creditor and the debtor might achieve certain agreement. So bankruptcy is kind of a Pandora box, and however this is going to be used and further developed. But once you can avoid bankruptcy and can achieve the results which you will arrive at, but for a longer time period as a result of the bankruptcy procedure, you can basically achieve in an alternative scenario and just save money and time on that. So we also need to dialogue with creditors, because there are creditors who are reasonable enough not to be aggressive to the debtor, who wish to step in their shoes because they're economically interested in retaining their counteragent, because they provide them with the necessary economic resource, some raw materials or products, and they want to keep them. So if they sense that their financial problems are temporary, and if the debtor can prove that this is a temporary problem, they can start a constructive dialogue. And driving to a close, I would like to say that during the legal drink yesterday, where all of us hope were present and had a good time, I just remember the phrase that law is the conciliation of different people's wills, and sometimes we disputed whether to go further to this bar or to this bar yesterday, and we achieved a consensus, an agreement whether we can go, whether we should go there or there. It is easier to reconcile the wills, especially if there is interest and goodwill on behalf of these entities. But to agree about the reasonable, it is easier to agree upon the reasonable restructuring in the pre-bankruptcy stage. However, it is more difficult when there are many contradictory, conflicting wills involved during the bankruptcy procedure in full swing. Thank you very much. Oh, you also have some other comments. Oh, yes. I just want to support Vasily. We know it. We have known each other. He is the MA program, the law department in the Moscow State University. Vasily was not present in the previous roundtable discussion about the bankruptcy of banks, and I made a comment there as well. It is cheaper and easier to prevent bankruptcy rather than bring a company to bankruptcy. We need to think very carefully what we can do in the bankruptcy prevention strategy and policy. Vasily spoke about the finding a balance and avoiding conflict, but this could have been reviewed in the macro and microeconomic level, and probably legislators need to start using more wide-ranging dispute regulation strategies and methods that are adopted in other countries. I'm not only speaking about mediation in conflict resolution, negotiations, and many others. Yes, thank you, Svetlana. And just another comment to Alla. Thank you, Svetlana, for this comment. So maybe as a result of this roundtable discussion, we will find some very practical solutions that might be further discussed and developed. Yes, Alla, picking up on what we were discussing in the previous session, and as to the business protection in bankruptcy, the question was voiced. What if we think about the mechanism by the means of which the debtor could inform and notify the creditor that he might potentially become bankrupt or he has huge problems? Of course, we can discuss different other alternatives, but there is a kind of claim-based process, but you can go to court without filing a prior claim. We're not qualifying it as a infringing upon the rights of both creditor and debtor. What do you think about such an instrument, so that the debtor will be on a compulsory basis notify 15 or 30 days prior just about his potential bankruptcy, so that he will not be able to repay his obligation? Yes, so my comment will be kind of an integrated one. If we're speaking about the bona fide debtor, he will be himself thinking about how he can best meet his liability, and it doesn't really matter that he might be just well-meaning, but he wants to retain his business. If he acts in good faith and if his attitude to the situation is reasonable, even if this obligation is not codified in the law, he will start a dialogue with his creditors, and he will notify them that currently, by this deadline, I would not be able to fully meet my financial obligations. Let's discuss rescheduling or prolongation of the repayment period. As to the law, as there is informing about the possible failure to meet his financial obligations and having it as a provision, the most important thing is how you can enforce this mechanism and what sanctions we can offer. So it is difficult to support it fully because we don't have the well thought through solution. However, good faith creditor debtors already do that in practice, and that's my name is Alexandra. My question is to Vasily. we have about 70 bankruptcy cases, and none of them would be of the kind you mentioned, that would be based upon the exit or wish to avoid the bankruptcy procedure. If you already have such a case, maybe you can share the strategy that underlies it. There's going to be a special topic of Anton Alexandrov's theme, and also if you have a comment, you will also be offered to time. But I want all the panelists to be part of the discussion, hence we're going to ask Anton Alexandrov to speak up. Yes, I would like to welcome and greet all the panelists. Yesterday we had wonderful weather, and hope today we're going to have the same weather. I'm surprised and fascinated to see so many people who stayed over after lunch to participate in further discussions. And I would like to throw in some positive attitude and speak about the mechanisms of exit from bankruptcy. Of course, one should do best to not to prevent bankruptcy. However, if you have temporary problems with liquidity, you might become prone to bankruptcy. So companies that have good chances of survival, though are hit by temporary problems, I would like to offer some statistic and provide some data and hope to get some feedback. So what do you think? What percentage is accounted for by the bankruptcy procedure winding up among all the cases? What is the percentage of winding up bankruptcy cases? Somebody said something, but I cannot hear. 91.3%, which is quite a lamentable thing. 1 out of all 10 cases end up having a liquidation or bankruptcy procedure triggered off. So let's look at how we can view the situation with the from the debtor and creditor perspective. From the debtor perspective, you can lose your business unless it is made into the mirror company or risks of the subsidiary and criminal liability, and reputational risk, because you can lose your reputation, and in the previous roundtable we talked also about the social responsibility, and many people will be laid off as a result of the business bankruptcy. So what is the winding up process? It's you can have 2 years spent in the courts, and so they get about 4 to 20% of the repayment at best. So the bankruptcy of the debtor can trigger of a chain reaction, and I think you can have numerous examples of trying to claim recover a debt, but the company is qualified as a bankrupt. It takes time, and then some other clients, the client also becomes bankrupt and he has to be protected from his own creditors and so on. So this is also one of the negative outcomes, and of course it's bad for your reputation and other things. So, apart from the liquidation or bankruptcy winding up process, we had financial recovery, external management, and amicable agreement. What else can we? What other alternatives do we have to that? Another to mention are still there. So repayment by the third party of the debt by the third party, and what else? And the So when the creditors give up their claims for the repayment, let's view all the procedures. So the financial recovery, the statistic in the last 3 years is staggering. So just the negligible amount of these procedures, only 11 out of 181, yielded a positive outcome. So this is the financial recovery's efficiency procedure, so it's just negligibly small and very inefficient. I'll try to offer my own rationale why we resort to this procedure very seldom. Probably because 2 years period is not enough, because it takes a longer time for the business to recover. So we can only agree upon the schedule repayment and fulfill it and unfulfilled under the threat of triggering of the winding up procedure. So the possibility arises when you have a pledge or a lien, and the managers of the company are very much limited in what they can do. So just 11 out of 180 procedures that were successful. External management also does not provide us with over-optimism, so it's used more often. However, maybe because there are more opportunities and possibilities to restore your solvency, well, you can have some mechanisms, but you need to take it down in the external management plan. Once approved, you have problems changing it on the go. And what's also the disadvantage of the external management, you have a wide-ranging set of instruments you can use, but on the other hand, there is a stranger coming to a company to stand for your manager, and he has to manage a business which is virtually unknown to him. So it's only 3% of success of all the procedures. So it's a kind of artificial coma before you sell the assets. Of course, we need to probably streamline the procedure, and it will be more efficient. The third mechanism, alternative, is when the creditors give up qualifying the debtor as a bankrupt, give up their claims. There are still, with this Etera company, there are still 3 claims which are valid. There are specific risks that the creditors see if he, in practice it sounds like giving up of the suit, and maybe we could use an alternative. We could probably do some things to secure it, and so another. So if you just reject it to pursue your claims, you cannot rethink it and bring it back. But on the one hand, you should provide for the possibility of exit the bankruptcy, and also give free rein to the creditor to resort back to bankruptcy if the situation gets aggravated. So this is a situation where all the claims of the creditors are fully satisfied. This is just an unrealistic and extraordinary situation. We understand that there is a my bank situation, which is basically prompted by some political or so in June they requested the suspension of the bankruptcy procedure because the credit was repaid, but It's still under investigation, so we don't know the final outcome. So amicable agreement has its strengths and its weaknesses. The amicable agreement, as any other conciliation of wills, calls for a compromise and a balance between different interests, and if one well, there's a will, there's a way of finding it. However, there should be some formal procedures, and just there are some formal provisions that you have to go through. However, sometimes this amicable agreements get publicized, and sometimes people are unwilling to do that because they'll acknowledge their weakness. However, they have amicable agreement has a lot of strengths as well, not only the weaknesses. What else do we have for the amicable agreement as the positive side? You can include any conditions there, unless these are prohibited by the law, which is a good thing, as compared with other alternatives where you are restricted. And there is it is very seldom that people challenge it or appeal it, because you have to provide a convincing argument in order to ruin it. It can be terminated only by the creditors that have no less than 1/4 of the votes. Then in our practice, in 2010, amicable agreement saved a big enterprise that is located in the town of Shakhty in Rostovsk Oblast, Rems, who had problems in the course of the last financial crisis. So the situation might repeat itself currently, and then there was a financial installment, five-year installment period offered, and then so the business was saved. The creditors got finally quite good repayment, so it ended up being a win-win situation both for debtors and creditors and other stakeholders and people who work for this enterprise. So that we had such a positive and very good example of amicable agreement. You can, when you sign it, in my practice, so there are no criminal claims pursuant, so subsidiary liability never arises as issue here, and just we keep the jobs. So we understand when the creditor says we have regulated the procedure, please let us do as we planned. I doubt that signing amicable agreement will lift all the legal and criminal risks and diminish them. Yes, but I'm afraid in practice this is not so. So we represent creditors who are kind of claiming their debt, but we see also how the debts protect themselves and why these amicable agreements were achieved. Because the longer the procedure of monitoring was, the more chances were on the side of the amicable agreement. Please don't get me wrong. I'm not calling you to use unfair instruments to procrastinate and prolong this process. However, there were attempts to suspend the judicial order just in order to prevent bankruptcy. Then just the bankruptcy petition was challenged and appealed. The case went to the upstanding levels, and it also suspended the case. So the representatives of the participant came up asking, querying, making an information query, and all asking for additional time. to study the situation. So the third parties towards the end of the monitoring process are just pledge providers and sureties who filed a petition, bankruptcy petition. The court rejected them and just they resorted to appeal mechanism, appealed the rejection to make them part of the case, and there's another 1 to 2 months procrastination followed. So the monitoring process is 7 official months plus 3 additionally possible. However, in practice, it might come to 18 months or so. When a creditor starts thinking whether to go along to move towards the amicable settlement or bankruptcy procedure, if you go for bankruptcy liquidation, so you'll be able to sell the assets in 18 months' time, and you never know how long you're going to stay under monitoring, or you can enter into amicable agreement now, have some, to an extent, good relation with your debtor, and offer installment possibility. Do I still have some time, or I'm already abusing my time frame? But well, it's what you're telling is very interesting. However, you also need to respect other people's rights to speak up. And lastly, I just wrapping up very quickly. So this is like a Lego toy, so you can build the optimal and most favorable and case-specific strategy that will be acceptable to all the parties involved. So the unorthodox and non-standard conditions versus the standard ones, which is the debt rescheduling or deferring the time or whatever. Some also wrapping up, because I also wanted to mention an interesting moment. Please have it.
Давайте я начну рассказывать немножко про нюансы заключения мирового соглашения, потому что все мы можем прочитать книжку.
So I can also recommend you a book, Bankruptcy or Insolvency Law, because practice and theory diverge sometimes. When you enter into the amicable agreement, you should remember that the liquidation or bankruptcy basically is targeted not at killing but curing the debtor. It's rehabilitation. So you have to be prepared that the amicable agreement does not end up to just one creditor getting what he claims, but that the company will be able to continue its business. Third parties involved are also taken on board, the ones who voted against, the ones who are still not part of the register. So such creditors should not receive zero repayment. So the creditors that are not involved should also get at least a minimum share, but they have to get something. So I'll jump to the last slide and then probably wrap up my presentation. Conclusions, because the audience would appreciate looking, you're bringing back another slide like this. So you can keep this slide on the screen while commenting on the conclusions. So a tilt or a bias towards liquidation is not time relevant. Of course, we need to do everything possible to use alternative recovery or rehabilitation and restoration procedures. So we know that in July last year, a roadmap was adopted in terms of improving the bankruptcy procedures, and it was rightly mentioned that one has to balance liquidation and rehabilitation procedures with no bias to any of them. There is no universal remedy, but once a working business came to the bankruptcy situation, the amicable agreement will be the most flexible and efficient exit.
Thank you very much, Anton. And do we have any questions? Yeah, there you go. Alexander, over to you. Alexander Mazigin from Commerzbank. You've given us very interesting statistics about the ratio between the types of proceedings. So we have financial sanation, we have external management or bankruptcy administration, and so on. So you've given us a lot of interesting figures. Have you seen or studied similar statistics for the Western Europe, United Kingdom, Germany, France, maybe? Well, that's not the question, I'm sorry, but what I'm trying to say that if you look at the statistics, then it will not really be too different. It might not be 91%, it might be 80%. But I have to tell you that the idea of bankruptcy, well, at least the idea of bankruptcy as it is in theory, is basically sanation of company of debts, well, legal debt sanation of company. So the company should undergo a certain procedure to have an opportunity either to exist without debt being transferred to another owner or be liquidated. And I have to tell you that when we talk about liquidation, it is not something that has to happen as a result of bankruptcy administration. We've seen a lot of the examples of how the companies have been transferred from one owner to another. Yeah, I think I understand that. So there's probably an alternative opinion, but what is your question? Well, my question is, why do you think that rehabilitation procedures are not interesting during bankruptcy procedures, or do not generate a lot of interest? Well, I do think that this, well, if you ask me at the previous discussion, I would have said that yes, I would have agreed with you, because you know, we represent creditors, so basically winding up proceedings is a traditional strategy. But since we are trying to look at the situation from the viewpoint of the debtor, I try to look at it from the debtor's point of view. So what is it going to be better for our debtors? As you know, when we talk about rehabilitation procedures, I think it is the time now for these rehabilitation procedures to be put at the avant-garde. In this country, the business is going through a lot of extraordinary problems, so we have to save and develop the business and not just use winding up proceedings to basically sell everything during auctions, so to lose jobs and to complicate the turbulent situation in any company. Do you think it's possible? Wouldn't it be easier to do it outside of the bankruptcy proceeding? Well, that's what I actually started my talk with, and I do support my colleagues. Well, we have to do everything to prevent bankruptcy, and I do believe that the representatives from the banking community are also striving to initiate dialogues. I really like the idea that Vasily voiced, that we really need to strive and achieve the dialogue, and this dialogue should be very helpful for everybody. But unfortunately, sometimes it's hard for people to listen to each other. There are some aggressive creditors who are not ready to engage in charity. They've given somebody the money and they basically seeking to return it. Some creditors believe in social responsibility, whereas others stick to the other point of view. They think that if they don't insist on bankruptcy, then they might default on their payments or payments to their account holders. So we have different points of view, but what we need to do, we need to come together and to find a compromise. I believe that there are ways to find compromise even in a situation when a company is insolvent. Anna Zanina, the Commerçant newspaper. Let me comment on the statistics about the financial sanction procedure. And again, let me say about the bias or the shift from to the liquidation procedures. I know that the regulations which have recently been published basically are dealing with designating financial sanction procedure as a different procedure that is not related to bankruptcy. And again, the monitoring procedure will only be done for 2 months and will only be applied in certain cases. So do you think that we really need to reduce the time for monitoring to 2 months? Well, you know, monitoring is actually a strange procedure, and a lot of people still do not quite understand why it is that we need it. A lot of law professors and a lot of lawyers really do not understand the need for this procedure, because basically it just means that everybody's losing the time. Of course, yeah, sometimes it just gives us a chance to catch our breath, but again, it is quite logical. You see that when it comes to financial sanction and when you see the statistics, and again, do you think a lot of people will actually use this procedure? And do you think that there'll be a lot of people who will be willing to help? I think there'll be quite a few people who will want to do it. I do think that if we talk about financial sanction or financial rehabilitation, some people will use this opportunity. But why the statistics is so low? We have a huge country with a lot of cases of winding up proceedings. So those companies that actually have future prospects, I think there are quite a few of them. So there are a lot of opportunities. Thank you very much. Well, just a very, very short comment. Thank you very much. You know, I don't want to appear overzealous, but I do not really have an opportunity to address the representatives of the business community, of fundamental science. There are not too many platforms where we can meet, and I think that there are a lot of things that we can discuss and say to each other. So I would like to support Anton by saying that if you think about it, why is that today we have to pay more attention to the positioning of rehabilitation procedure? Well, basically, lawmakers lumped together two categories: insolvency and bankruptcy. These categories are different in their nature. So my colleague who says, why do we need rehabilitation procedures when liquidation is bankruptcy? So both Anton and Alexander are right in saying that it is so, but I do believe that the initiative to basically designate financial rehabilitation as a separate thing is not new. Let me tell you that in France there are two laws: the law on financial sanction and the law on bankruptcy. This is again something that we've been talking and writing about 7 or 8 years ago. So I think that there is a trend for the financial rehabilitation legislation and a trend to have a separate bankruptcy law. So I have a lot to give the floor to Alexei Kozyakov, managing partner of Ivanian and Partners. So Alexei will tell us about how we can protect the debtors and founders from unfair actions or from the abuse of power of creditors. So before I start with my speech, so let's talk about the abuse of power, or let's talk about bona fide or non-bona fide debtor. So basically, since we are talking from the viewpoint of the debtor, we see that people who work with debtors and people who work with banks, they are actually in opposition to each other when it comes to honest or dishonest debtors. And I think that the second part of the discussion that we had was very timely. So let's look at the bankruptcy law from the viewpoint of saving of the debtor and actually restoring the payment power of the debtor. So basically, you know, we are saying, Anton gave us the statistics saying that these rehabilitation procedures do not really work in our environment. When the banks are declaring their interest, when large enterprises are trying to introduce amendments to the bankruptcy laws so that they can preserve their paying capacity, I have to say that a lot of the bankruptcy laws involve the mechanisms of the abuse of law. So basically the trend is changing. First, they give more power to the creditors, then they restore some power of the debtors. But basically what it is used like a weapon. Sometimes one party abuses this power, sometimes the other party abuses this power. So basically, sometimes they conduct a meeting, they identify the property selling procedure. After that, the rest of the creditors join the meeting and they're trying to put all of the requirements in the register. So here, of course, we can understand the creditors when they want to introduce the measures which existed in 2009, that they cannot really call a meeting of the first meeting on bankruptcy until all the creditors are present. So basically, if you look at this procedure as a mechanism of the abuse of power, what it makes all of the paying capacity of debtors as ineffective. When we are discussing an amendment, any amendment, we usually think, how will a dishonest debtor or a dishonest creditor use this amendment? So basically, in case when we have a third-party investor who wants to help the debtor and who wants to save its business, and if they decide to proceed with an out-of-court of settlement, well, they cannot really do that, because first, they cannot vote during the general meeting of creditors, and usually, well, you always have creditors, so who will be able to block the making of the decision? And the only way to influence the debtor to proceed with an out-court settlement are basically just the figures. So we can just invent a debt. So a large debt is invited, and they basically proceed to the out-of-court settlement as a legal way to provide a discount to their creditors. Of course, the creditors do not really like such out-of-court settlements because, and they're using all mechanisms at their disposals to try and get rid of these provisions. So in my speech, I would like to say that because we have such a view of the bankruptcy law, basically right now the law is being skewed in favor of creditors, and it creates a lot of possibilities for the abuse of power and the abuse of law. So honest debtors, when they're going through bankruptcy, they're usually trying to resolve this procedure without abusing their power, and there are not a lot of mechanisms that would allow them to achieve that. I have to say that even those mechanisms will be removed in the future. So if we talk about the objectives, we usually see two objectives here. First of all, creating a potential way out of the procedure, and the second opportunity is creating a way out of the procedure while retaining as much of the property as the debtor had before the bankruptcy proceedings were initiated, because usually a debtor can lose a lot of their property and assets during the procedure, or they can monetize it in order to achieve their paying capacity. We believe that when it comes to the goal of the objective, well, a debtor can have a way out of this procedure. So how can they do it? Well, basically, we all understand that as a rule, creditors use a standard tactics. They want to move as fast as possible to basically to the winding up proceedings, and why they think it is better, why they're trying to achieve it faster, because of course they do not want to be encumbered with a debt that creates more difficulties for them in terms of their balance sheet. So they believe the winding up proceedings will allow them to get whatever they can, and they can write off all of the debts. And unfortunately, when we deal with banking creditors, sometimes the banks are not even interested in the size of the debt. If an out-of-court settlement is reached with the debtor, you can be suspected in a conspiracy, so in order to achieve a legal discount. But if we are talking about the satisfaction of the creditor's requirements, but they still got nothing, this is not a problem of the bank. This is a problem of the lawyers who tried to save the owner of the business and who tried to save them from criminal prosecution by actually taking and transferring all of their assets out of the business. That is why the creditors are not too interested in reaching out of court settlements. So what can debtors do in this situation? Well, virtually nothing. There is just one thing that they can use, which is a monitoring procedure that we've already mentioned. So when the monitoring procedure ends, then the creditors have to make a decision about the fate of the company, which procedure should be applied in the future. So basically what we have, the creditors have the right to the first night, so to speak, and they determine where the company how the company should evolve, so that there is a financial rehabilitation procedure that can be done at the request of the debtor, the founder, or a third party. But unfortunately, this procedure functions rather poorly because the limitations that are imposed by the law in bankruptcy, what they do, they're trying to prevent the abuse of power from the debtor, the abuse of the opportunity for financial rehabilitation. So they limit it to a year, and they really limit the time that the debtor has before they need to start paying. It's limited basically 2 months. So what can I tell you here? I do not really think that any debtor can come to a bank and get a bank warranty, especially from a bank that evaluates the situation fairly, especially when they have 1 billion or 2 billion rubles in debt. Well, it is only possible when the debtor secures basically the help or the warranty of another corporation. So I believe that this mechanism doesn't really work, and we have only one realistic opportunity, which can be split into basically two aspects. One is when the creditors haven't reached a definite decision, then in this case the decision lies with the court, and here a debtor has an opportunity that sometimes they can have external administrations. There are some features of paying incapacity, which gives us, which give the debtor hope to actually reach payments to their creditors. But it is, of course, difficult to make all of the repayments in 18 months, and it would have been much easier had this framework been extended. But there is also an opportunity for the debtor to basically dispute this issue with the creditors. When the creditors have voted, for instance, when the creditors reached a consensus about the next procedure that should be done, or about the bankruptcy administrator, and when the decision was made at the first meeting. In this case, not everything is lost for the debtor. There is also the law also describes a dispute resolution procedure, so the debtor can submit a claim or a complaint about such a decision, and they can even win the proceedings if they prove that all that the debtor is trying to achieve is to initiate the winding up proceedings. Well, of course, you have to prove this intention of the creditors, but you can do that if you have evidence that the creditors understood that such an opportunity existed. So I understand. I understand. I'm almost done. Yeah, I know I've selected a highly disputed procedure, and we know that the Sberbank of Russia usually says that you cannot actually appeal this decision. So that's why I'm actually saying that you can, so that I can initiate a discussion on the topic. So basically, the next aspect of such actions of the debtor. So if the decision of the meeting of creditors is declared as invalid and there is no time for the monitoring procedure, then the court can make a decision about not holding any such meetings anymore, and it will be the court who will decide on all of the future proceedings. So one of the possibilities for the debtor who doesn't really have such a huge debt and who doesn't really have a rich party who can actually cover its debt in favor of the creditors, or unless there is a strong will to reach an out-of-court settlement. But if we talk about possible abuses from the creditors when basically they are trying to claim the property, to find a full recourse of the property of the debtor, basically to achieve the positive result of the bankruptcy, then in this case the debtor can still retain some property. And I think the second objective is that an honest debtor usually knows that even if his property is not enough to settle all of the issues with the creditor, it's actually better when they have more property, so that they do not really have any creditors who would like to file a petition under Article 159, so they will have only a few of such creditors, or none at all if possible. So I would recommend you to use a couple of mechanisms. First of all, while the petition in bankruptcy is being reviewed, either from the debtor or from the creditor, all entities or all stakeholders of the proceedings need to have an opportunity to submit a petition for the exception. For instance, exception to bank write-offs of the debtor's accounts, and basically so they can write off or dismiss full recourse to property as a part of standard procedure. This is again something that is being done, and these measures are used quite widely during bankruptcy proceedings. As you know, the mediation courts usually view it quite narrowly, but the second stage is when the bankruptcy procedure has been initiated, the monitoring is in place, all of the measures will be removed in this case, but again, the law envisages an opportunity to ask the court to actually introduce injunctive remedies. And I have to also draw the attention of current creditors who frequently abuse their power. The debts can be quite large, and it can prevent the debtor from participating in bankruptcy administration procedure or in the monitoring procedure while they still have a chance to salvage their paying capacity. And to conclude, I would like to evaluate all of the novellas in the bankruptcy law that actually they extend the rights of the pledge lenders. But in my opinion, what they do not really take into account is the necessity to provide adequate mechanisms to the debtors so that all of the disputes regarding the initial price, which is set during the auctions at the request of the pledge lender, are settled. So I think that this mechanism should be defined more clearly in the bankruptcy procedure. I would also like to draw your attention to another fact. So if we are trying to prevent some dishonest actions from these pledge lenders, basically what we're talking about is the repayment by the founders of the debtor or people who are providing the warranty, well, basically repayment of some of the or part of the requirements of the creditor when the debtor has no opportunity to fully repay all of the claims from the creditors, and because they do not have financial solvency, while still trying to save their company, what they can use financial means that they have, or the financial means of their stakeholders, so that they get a status of the pledge lender, because then the pledge lender's rights will be transferred to the company which repaid part of the requirements, and a dialogue will be initiated. Unfortunately, the framework for such a dialogue hasn't been clearly defined, and what the arbitrate court said, it doesn't actually clearly define who will have an advantage and which one of the pledge lenders, the existing one or the new pledge lender, which one of them will actually determine the property auctioning procedure. Well, we are reaching the end of our discussion. We still have three topics. We have three questions and three topics to discuss. So maybe let's vote on these issues. At the same time, I would like to address our Japanese colleague. And I'll give the floor to our Japanese colleague to tell us about the Japanese experience. What is it that they do in Japan? Do they try to save the company or not so much? Over to you. Please try to stick to about 7 minutes or so that we have 3 minutes for the voting. Aki Agawa, a partner in a law firm. Over to you. Good afternoon. I'm Japanese. I'm 43 years old. My name is Aki Agawa. For me, it is a great honor to come to St. Petersburg again, to participate in this forum, to meet all of you. If you would allow, I will proceed in English. My Russian is not so good.
Now start. Well, I'd like to start with the idea, rescue rather than liquidation. In Japan, although there are 5 tracks of court procedures dealing with bankruptcy, the most frequently used are such 3: liquidation, company reorganization, and civil reconstruction procedures. The first is just as it is, just liquidation, just destruction of the assets and management. And whereas the latter 2 are the business restructurings. That is one of the best features to illustrate the Japanese scheme. In light of the protection business, it is obvious that rather than business is wound up and all liquidated, survival of business is more meritorious to all of the related parties. For example, creditors would receive better repayment. Employees and the shareholders might have the possibility to stay. And the debtor might maintain his business. And ultimately, society could avoid the social and economic loss, which would otherwise be caused by liquidation. So in this brief presentation, I've narrowed down the focus more on the company reorganization procedure and the civil reconstruction procedure in Japan. One of the significant differences between these 2 schemes are whether or not so-called debtor in possession is incorporated or not. Considering about the business protection in Japan, it is difficult to avoid the impact of the US Chapter 11 on the Japanese bankruptcy law. Before the burst of the bubble economy in the early 1990s in Japan, there used to be only company reorganization code, where court-appointed administrators, basically acting on behalf of all the creditors, will take over all the management power and assets of the company. With the burst of the bubble economy, Japan has been suffering from long, very, very long, serious economic recession. When the numerous companies, even mega banks, went bankrupt. Mega banks went bankrupt. The thousands of employees lost their jobs. In Japan, here the idea was born that it is rather difficult to attribute the current economic plight in the company only to the incompetence and the mismanagement of the directors. It could be said that debtor company is also one of the economic victims, and they should be given more positive chance, the second chance for the fresh start. here the dramatic change of the bankruptcy philosophy in Japan is recognizable. From pro-creditors to pro-debtor. And in 1999, sorry, not 2001, 1999, Civil Risk Construction Act was introduced. Now, I would briefly illustrate the procedure of a civil reconstruction case in Japan. Initially, mostly it is the debtor who files the application for the civil reconstruction procedure to the court. And if the court considers the statutory cause of the commencement is satisfied, the commencement order is rendered from the court. So now it's under the procedure of the court. With such commencement order, any unsecured claims are not allowed to receive repayment. So once all suspended, without participating in reconstruction procedure, for example, filing, investigation, report, proposal of plan, and its resolution. This means the debtor company during the time of the procedure basically does not have to repay to all the unsecured creditors. And more exactly, he is legally prohibited from repayment. On the other hand, in civil reconstruction procedure, the debtor usually managed by previous directors, because it is a debtor imposition, which still maintains its management power over the business and the assets. So the business is protected and still carrying on during the procedure. Mostly within 3 to 5 months from the commencement order by the court, debtor needs to propose a reconstruction plan under the court supervision, which must subsequently obtain the resolution in unsecured creditors meetings by majority rule. Here, majority rule means even the dissenting creditors are bound by the resolution once it is resolved so. So that if you are acting on behalf of the debtor company, just 51% consent is enough in order to bind the dissenting creditors to accept the plan. So, even if the plan was not able to pass in the creditors meeting, the debtor is entitled to submit the amended plan. But it is limited only one time. So failing even the amended plan, court shall order compulsory liquidation. Here in practice, I'm talking about the practice in Japan. Usually in Japan, when the company goes bankrupt, the dividend ratio in the case of liquidation is less than 5%. Less than 5%. Как сказать по-русски? Ниже 5%. So here is the large scope of the negotiation between debtors and creditors. If you are debtor, if you are acting on behalf of the debtor, acting attorney on behalf of debtor, you could say, we will suggest 10% of the dividend ratio in our reorganization plan. Whereas in the case of liquidation, it will be only 5%. So please think about.
Aki, 1 minute left.
1 minute.
Yeah.
Okay. The economic rationality. Okay, well, I played many things, but okay. So about the criminal risk. Sometimes attorneys is put in a very difficult position. He gets paid from the client, the debtor company, but sometimes debtor company, especially the directors, try to commit some sort of criminal offense to hide the assets, maybe fraud, bankruptcy. So it is very important for the attorneys to have the very high quality, high level of professional ethics. well, I also dealing with a lot of bankruptcy cases, so I know it is quite a difficult issue and quite understand the case in Russia. And we also, lastly, just 30 seconds, please. I will close my presentation mentioning to the DIP finance. DIP finance. We have something called DIP finance under the governmental authority, which is called Development Bank of Japan and many private banks. It is obviously important in the financial sense as well to contribute to a business protection and rescue during the procedure. Thank you very much for your attention. Thank you so much. Большое вам спасибо.
Thank you very much, Aki. Большое спасибо, большое спасибо. И, друзья, очень хочется... Мы, правда, ровно сейчас 17:30. Я предлагаю, Василий Родин подготовил очень хорошие вопросы, и мы быстро, то есть от всей нашей, предлагаем вам проголосовать. Возьмите в руки устройство, мы посмотрим срез, такой снимем срез нашей аудитории. Вот, у кого нет, у меня еще... Анна, может быть, вы проголосуете?
So we would like to offer you to vote. The questions are the following. There are 3 questions and 3 answers to each of them. And we'll see, well, these are put up on the slides. Number 1 question. Should I read it out loud, or you can read it yourself? Okay, then you read it yourself and vote accordingly. Display your vision and understanding. So the question is, when you hear about a high-profile bankruptcy case, how do you see it without knowing the details? A, as creditors attempt to take over the business. B, as debtors attempt to reset the debts, having previously siphoned off the assets, and C, as a logical result of business activity of a given company. So you press A, B, or C.
Все нажали. Так, какие у нас выводы?
Yes, so here's the results of the voting. B as an attempt just to zero off the assets by dissipating assets. So I press for C. However, the majority think that well, this is the result of the whole session. We are protecting the debtor. Who are we protecting, really? The debtor who is dishonest and not acting in good faith. So basically, we are the audience and the panelists. The majority thinks that the debtor is dishonest by definition. Well, if I could press 2 buttons, I would have done though. I would have pressed C first and B second. What did you press? I also pressed for C. And me too. So, well, all the panelists so it's Friday night, and we are voting for unfair and dishonest debtors while we're discussing the necessity of viewing debtor as an honest and good faith and protect his interests. The second question. The second question is, since 2015, the minimum amount of debt necessary for a creditor to initiate bankruptcy procedure in Russia increased from 100 to 300,000. Do we need to increase this sum in order to protect the interests of the debtors? Yes, because under the current regulation, large company can end up in a bankruptcy procedure after a relatively small debt. and B, no, since large company must be able to pay off a relatively small debt, and C, minimum set of bankruptcy procedure requirement is not a key indicator for debtors' right protection. Well, yes, the prompted answer is yes. However, because we had the explanations, we need to press C. So it's not the answer does not lie on the surface. So who would like to comment upon the result? Vasily, what do you think about your question? Dear colleagues, it is with satisfaction that I notice that since we see a lot of similarities here in distribution in the most similar proportions, I think that this threshold is sufficient, because if a company is a big one, it can find this sum to repay the debt that triggered off the bankruptcy procedure. But I'm very happy to see other viewpoints reflected in the voting, because we see the votes distributing in a very proportional way. So we're not speaking about the arbitration court, we pity it. And the third question, so you can see it on the screen, since 2015 debtors do not have the right to suggest the court of their own arbitration receiver or their own at their own discretion. Should the same restriction be introduced for creditors? Yes, the current regulation provides unfounded preference to creditors. No creditor's right to suggest the arbitration receiver. It does not violate the equal state of the bankruptcy procedure. Principals, participants, and any particular candidacy of the arbitration receiver does not play any decisive role, especially when one of the creditors has a majority of votes in register. So, while we are still waiting for the voting results, I would like to provide a short conclusion. So I would like to praise the constellation of our panelists. And when I was asked to moderate this meeting, I was in doubt because I wasn't an expert in this field, but I now know much better because of the contribution of all the panelists, which I just enumerated: Valery Zinchenko, Arki Gava, and others. So you're all outstanding, very knowledgeable people, and I would be happy to cooperate and communicate with you as to developing a common position. Yesterday we spoke with Minister Konovalov, and I agree that we are here to develop a certain opinion and our approaches to these issues. So we speak about the protection of business or debtor, and speak about the bank's perspective if the banks are creditors. So we need to strike a balance and achieve a consensus. Vasily said the conciliation of wills, and I just wrote some quotations for the materials. Bankruptcy, it's better to prevent bankruptcy, because once it began, there is no stopping it. So A got the most votes. So for the ungrounded preferences to creditor. Well, I think that A choice reflects that we perceive the bankruptcy procedure and the receiver procedure as a tool, as an arm. So let's provide everyone with the fair rules of the game. So we can have the receiver who will respond to the C, because if his role is not decisive and he's not a criminal who wants to sell the debtor's assets to affiliated persons, he will really be under category C, when it doesn't matter who proposed him, who he is, and so on. I just want to respect the timing for the session, and you can continue your exchange on one-to-one basis. Thank you all very much. Thank you for coming, and I hope that we'll continue communicating within the just framework of our Russian Corporate Counsel Association, and we will also be happy to continue with you. Just have a good night and goodbye.